Yes, ma'am. May I have a lordship's leave to mention for drawing up and completing an order passed on 18
For
drawing up and completing the order.
yes.
18 July 2025. If your lordship would kindly grant me leave.
Should we can we do that right now? I mean, without putting it on the list.
Yes, my lordship may grant
Please
the
grant
leave.
it. Yeah.
And
Please grant.
grateful.
Lord, I am appealing for the alleged contempt. Last
But I am for the petitioner, my lord. Last petition, my lord, we have received the payment, my lord. And one submission, my lord, the petitioner has to incur a huge litigation cost. My lord, some penalty should be imposed. That's up to
In
your lord.
contempt, we cannot add anything.
But there is a violation, my lord. Contempt was there because they have violated the order. But something none.
We'll record that, but no. Learned counsel for the petitioner submits that although the amount due to the petitioner has since been paid by the alleged contemner, some penalty ought to be awarded due to the delay in making such payment. Next para, however, considering the facts of the case and that the contempt has since been purged, although belatedly, this court is not inclined to grant any penalty for the alleged contempt, in view of the matter having been resolved, CC 68 of 2025 is discharged, stands discharged. The connected contempt application stands disposed of.
Great.
CC to contempt application. Rule to issue হয় না এটা।
Yes, my rule was
Rule
issued.
নাম্বারটা কত? রুলটা তো লিস্টে থাকবে। সিসিটাই রুল। রুলের আলাদা পড়ে না ওই সাইড। যা বললাম তাই। হ্যাঁ।
Great.
Thank you.
Hey, please, my lords.
Yes.
My lords, may I request your lordships to first take up item number 3, because I'll tell your lordships, item 2 is an application for perjury,
2, 3 একসঙ্গে পড়ে দেখান।
but if your lordships takes up 3, my lords,
কি করছে? ঠিক এটা দিলে?
is an
ঠিক এটা?
না।
পরে দিয়ে। ঠিক আছে। Yes. 3.
is an application for modification of your lordship's order.
Yes.
Now, my lord, perhaps the name will my lord, sorry, a bell.
Name is striking, but
Yes,
striking
and I'll
forward,
tell you,
but-
lordships, some seriousness. I appear for Life Insurance Corporation of India.
Right.
I am a creditor of this particular company. Your lordships have also, lordship's order have also recognized that without taking your lordships to the papers. Well, as my admitted claim as on date is 4 crore 19 lakhs, which has been admitted by the liquidator. Now, my lord, your lordships will remember, my lord, the liquidator came and approached your lordships that I have deployed certain security agencies in a property in Mysore. And there, my lord, a shocking figure of, my lord, and your lordships have also noted your lordships' concern and that this can't happen, of 5,42,000 per month for security services, for which, my lord, now the entire claim on account of the security services has come to a staggering figure of 1 crore 19 lakhs. And with a claim of, my lords, 4 crore 19, I am being called upon to, my lords, pay a sum of almost around 60 lakhs on account of the security services. Now, your lordships, my lord, I will not take your lordships to anything. Would your lordship just take up your lordship's order of 3rd October 2024 first, page 57. Your lordships will read through it and your lordship will understand what has happened. Your lordships, this court itself raised a doubt that how can this be happen, and there is something fishy that is going on. Now, my lord, I'll tell you, lordships, what has happened. We inspected the property and, my lord, we actually made a surprise visit to see whether there are actually any security guards or not. There is nobody. No security guards deployed, nothing. We have videographed it, video recording, my lord, I have it on my pen drive. I have annexed the photographs. We entered the property and, my lord, the lawyers and the, my lord, the officials of LIC have also, my lord, given a report to that effect. Because, my lord, when we inspected the property, there is nobody. In fact, there is signage of some other companies there. So, my lord, would your lordships kindly seize your lordships order 3rd October 2024 once, page 57. Well, if your lordship goes through it,
What is the order of which modification has been?
well,
sought?
modification is a subsequent order of 10th January 2025. But,
What happened? Yes.
but before that, kindly your lordships would see your lordship's order of 3rd October 2024.
We expressed apprehensions, yes. But
No, not only that, my lord, would your lordship seize the entire order? Not only apprehensions, your lordship said that kindly sees page 57 once more. And I'll show at page 60, 59 and 61.
yes.
Well, your Lordship's order starts at page 57.
Hmm.
And would your Lordship see page 59?
Yes.
Well, last paragraph onwards. In fact, on previous direction of court, the purported security agency has also filed an affidavit where they have staked claim for providing security guards for protection of the subject property. From the bills annexed to the said affidavit, it transpires that the security agency has charged an exorbitant amount to the tune of 5,42,941 per month for deployment of only 20 security guards and one supervisor. Then kindly turns the page. Learned counsel for the intervener has rightly argued that apart from the said amount being expressly exorbitant, fact remains that by virtue of the order of the division bench, the official liquidator could not have taken physical possession of the property at all. Hence, there arises no question of deployment of any security guards in the property by the official liquidator. In fact, the intervener seeks from the court an order of appointment of a special officer to immediately go to the disputed asset at Mysore and ascertain as to whether any security guard has been deployed in the property or not. Then, learned counsel for the official liquidator, so and so. Now, would your Lordship kindly come to page 61. What is apparent, this is very important. What is apparent before the court is that not only are the bills raised by the self-proclaimed security agency exorbitant, much doubt is cast on whether the security agency is actually entitled to such charges. There are several suspicious circumstances involved here. First, the security agency operates and has its base in Kolkata, whereas the property in question is situated in Mysore. Doubt arises as to why the said security agency was deployed for protection of a property in distant Mysore instead of appointing a local security agency of Mysore, which would be much more cost-effective and congenial to preserve the funds of the company in liquidation. Secondly, in view of the specific observations of the appellate court, which was extended from time to time, that the official liquidator shall not take physical possession of the asset, the claim of the official liquidator of providing security for the property is on the face of it is not credible. Then further suspicion is cast on in view of the stand taken by the official liquidator in paragraph 16 of his own supplementary affidavit, where he states that boldly that the division bench directed the official liquidator to continue in possession till disposal of the appeal, whereas the facts are precisely the converse. The division bench having restrained the official liquidator from taking physical possession on the observation that merely a seal had been put on the property. Now, the property in question apparently comprised of 8 acres of land, so and so of building, seal, and according to the intervener, only a building where the entire balance is still in the occupation. Now, your Lordship is 62. At this juncture, learned counsel for the official liquidator seeks to place reliance on the purported minutes of meeting held on between the ex-directors of the company in liquidation and other stakeholders, from which it would allegedly be seen security agency was deployed within the knowledge of the directors of the company. Moreover, it is reiterated that the possession was taken by the official liquidator in presence of the ex-directors of the company, as well as local police authorities. In order to give an opportunity, this is very important, why I'm saying that there's been now a perjury. In order to give an opportunity to give the official to bring to the relevant documents on record, the official liquidator is granted a further opportunity to file a supplementary affidavit to bring on record all further documents. However, it is made clear that this is the last chance being given to the official liquidator to bring on record all relevant documents, and no further opportunity will be given on every occasion the matter is taken up to improve his case regarding actual expenditure incurred. After such submission by the official liquidator, learned counsel for the secured creditors in unison kindly notes this: submit that no intimation or consent was given or taken in respect of deployment of security guards to or from the secured creditors. Such contention is controverted by the learned counsel for the official liquidator, who assures the court that relevant documents in this regard shall also be produced before the court. Let's pausing here for a moment. Not a single correspondence was, before deployment of the security guards has been annexed to the petition, even the supplementary affidavit, to show that before even deciding to incur such a huge expenditure, consent of all the secured creditors were taken. Now that your Lordships kindly sees, let all such documents be part of the supplementary affidavit filed by the official liquidator. In the meantime, official liquidator shall circulate of all copies of all pleadings filed by it among all the other parties, including the intervener as well as the secured creditors, before the next returnable date. Now, then your Lordships kept it. Now, on the returnable date, he filed a supplementary affidavit. This is where I'm said that this court was misled. And absolutely facts were suppressed from this court, because in the supplementary affidavit, your Lordship's direction was show that consent was taken prior. After your Lordship passed this order, now your Lordship sees the impugned order. Why I say perhaps a fraud has been perpetrated on the court. Well, let's kindly see page 64. Page 64, my lords, 10 January. Would your lordship see page 65 now, the last paragraph onwards? On a previous occasion, on 3rd October 2024, this court had recorded certain apprehensions with regard to the prayer of the official liquidator for disbursal of the dues of the security agency. The plinth of such apprehension was twofold. First, that the security agency operating from Kolkata was deployed for providing services in respect of a property in Mysore. Secondly, there was a question as to whether the official liquidator has actually taken physical possession of the asset. The dispute arose from a direction passed by the learned single judge of this court directing the official liquidator to take possession. In the said order, December 25, 2020, which is annexed to the supplementary affidavit, it is found that the Commissioner of Police in Mysore City was directed to ensure all possible assistance provided to the official liquidator to take actual possession. Learned counsel for the official liquidator places reliance on a subsequent minutes of meeting of the very next date after passing of the order, where the concerned officers of the local police as well as official liquidator and his representatives along with the representative disclaimer applicant were present. It transpired from the said minutes that at least notional possession of the property was taken by the official liquidator on the said date and security guards were deployed. On the very next date, Malad, this is the challenge. I'm not troubling your lordships. Please kindly come to page 67. Well, second paragraph onwards. Upon perusal of the said order of the division bench, this court is of the opinion it clearly records an admission even on the part of the disputing disclaimer applicant that the seal was put by the official liquidator on the main entrance door of the property in question. As such, the property is definitely under the notional possession of the official liquidator, and official liquidator was justified in deploying security guards to protect the property. Then kindly says on the issue as to whether the official liquidator was justified in appointing security agency based in Calcutta for a Mysore property, it has been rightly submitted by the learned counsel for the official liquidator since such appointments are for sake of transparency made from the panel of security agencies made by official liquidator. It would be deviation from the said norm in the event of a local security agency of Mysore was appointed. In any event, it is submitted that the local personnel from the vicinity of the property were appointed by the security agency of Kolkata, which was engaged by the official liquidator. At this juncture, learned counsel appearing for Life Insurance Corporation of India as well as UTI, two secured creditors contends that the number of security guards may be decreased since the present deployment is incurring huge expenses which would ultimately eat into the entitlement of the secured creditors. Upon hearing the learned counsel for the parties and perusing the documents annexed the supplementary affidavit, the supplementary affidavit perhaps was this thing. The court is satisfied that the expenses claimed by the security were actually incurred by them. Accordingly, CA so-and-so is allowed, thereby directing the official liquidator to disburse and keep on disbursing the payment of the security agencies deployed by the official liquidator for the protection of the Mysore property. However, it will be open to the official liquidator to consider as to whether, keeping in view the area of the property and the location thereof, the number of security guards may be reduced or not. Now, my lord, would your lordships take up page 72 once, pursuant to your lordship's order? 17th January 2025, page 72. Would your lordship see this is a letter written by the official liquidator to, my lords, all the secured creditors. My name is in item number 2. And would your lordship see, my lord, at page 73, your lordship's direction is quoted. Now, please see page 73, my lord, bottom, last paragraph. It appears from records that the security agency with Shiva Shakti Security has an outstanding security expense of 1,19,44,000 for the month of, kindly notes the date, March 2023 to December 2024. Plus, greatest of respect, even for security, even for to guard a 5-star property also, I don't think this amount of expenses will be incurred. Then kindly see page 74. In compliance of the order dated 10th January 2025, the proceedings ratio to distribute the outstanding security expenses between the secured creditor, respectively, present in future. Accordingly, the secured creditor have to pay the security expenses. Kindly see the amount mentioned, SBI, LIC. Now, LIC, they write, it's 54 lakh 28,000. In wording, all of a sudden it changes to 52 lakhs in words. Maybe, that's a typographical error, but it looks like different. Now, kindly sees latest statement of the security bills for the month of March 2020 are enclosed herewith for your information. A meeting, kindly notes this, a meeting will be fixed in terms of the order to discuss an issue regarding reduction of security posted at the factory at Mysore, Karnataka. You're requested to comply with the order of so-and-so. Now, please see the next page, page 75. This is very important. I understood that there is something suspicious that is going on. I deployed, your lordship knows LIC is also a government concern. Now, I deployed my inspectors, my officials, along with malad, a learned advocate practicing malad in the local courts to carry out an inspection. Please see page 75. 19 June 2025. Detailed report of spot inspection done at company Remington Rand India Limited situated at so-and-so Mysuru. Well, this is the report. As requested by LIC of India, Central Office Mumbai, I visited the caption site along with the officials of LIC India on 12/5/2025 at around 11 a.m. 10/6 at 11 a.m., 8:30 p.m. On 10/6/2025 at 8:30 p.m., there was no light and was fully dark. The photographs was taken with the help of the car's headlight. The site was visited on the next consecutive day again on 11/6/2025 at 11 a.m. and no security guards were seen at the property on all 4 occasions. On 4 occasions they're gone. There is no display board of the company Remington Rand India seen on the said plot of land. We continued our search on the basis of boundaries of plot so and so and Google location with the help of local people, local vendors who confirmed the property. On our search, we located, this is very important, someone else's name. The industrial land plot 85A, wherein towards the north there is road, towards south there is open land, towards one occupied by Mrs. Rand Madras Company Limited towards West Road, and plot number 85 to 87 Silent Shore Resort. The site premises location further was confirmed from the nearby companies and the local vendors beside the company Madras Cafe Limited. In the located plot number 85A, there was no display board of Remington Rand India Limited. Instead, in northern side compound wall attached to the gate left, there is a freshly painted display board of JP Trading Company Limited. Well, your lordships will find the name JP in the order of 3rd October 2024. And towards the right side of the gate, there is freshly painted board of Shiva Jute Mills Private Limited and Sai Jute Park Private Limited. It is observed that these display board are newly painted and affixed on the walls of the company. It is observed that there are 2 gates on the north side, front side of the company, and both the gates are locked. There is barbed fencing with stone pillars in the north side is facing the road. There is no gate at the back side of the company, and we could easily enter into the site from the west side road. From the south side road, there is an open land which is close to the residential area. The land is open and anyone can enter through the south side of the property. On all occasions, the site visit, it is observed that there was an auto rickshaw and a defunct, obsolete old vehicle Maruti van parked inside the premises. It is seen that anybody can easily enter into industrial land. So and so on all the 4 occasions, there were no security guards seen at the company premises. It was also observed that at the industrial site, there are 4 buildings which are totally empty and all buildings are in dilapidated conditions and it is without care since decades. There's a growth of bushes and growth of saplings on the structure of the company. There is no found in and around the premises. The entire premises are completely unmanned. The backside of the premises is completely open for easy entry of anybody. It is confirmed that on all 4 occasions of our visiting the site, it is found that there are no security guards deployed at the industrial land of Remington land since long time, and there are no traces of any person visiting or staying in the premises during day or at night time. Anybody at any time can take an easy entry to the industrial land of Remington. We have taken photographs with Google location with time and date, with longitude and latitude of the subject premises. The entire industrial area of the company on all 4 visits was found unmanned and no traces of any deployment of security guards are there. The photographs are taken from the mobile of so Administrative Officer LIC Mysuru Division, St. Brand. Conclusion, your lordship is on the spot in which it is found so is not under body's care and nobody's care, anybody's care, and no security guards were deployed. Now, could your lordship sees the photographs? It is lordship's copy is
Colored.
as color. Your lordship sees this is taken on GPS map camera because to so that even now lordship sees I have all these other photographs here. Now today the official liquidator is going on asking for this particular share of money, and with your lordship's order, that supplementary affidavit was filed. Would your lordship not see? It's all post facto. Now he's calling me that whether less security guards have to be deployed or not. But today,
So that liberty was given to them.
correct. And liberty is on the basis of our apprehension. But today, please appreciate if this huge sum of money, which is why we wanted to.
This does not furnish a cause of action for modification of that order.
No,
This is not a
maybe-
case of modification.
maybe-
There is security lapse definitely if these are correct. But the veracity of these have to be challenged. They have to be given an opportunity.
no doubt
Approach the
about it.
company court will give you the leave. to remove the security agency if necessary,
But
you put your own thing.
in the meantime,
Yes.
Malaj, I am saying that in the
That
meantime,
does not absolve you from paying the money.
no, Malaj,
You can also challenge the quantum which has been raised by them.
I have, because if there are no
The
actual-
modification of this does not call for a
Malaj,
modification
I
of the
understand
order.
that. I understand that. What is
We
fine,
directed them to, I directed the official liquidator to pay off the amounts due to the
correct.
security agency.
Now, Malaj, if
And go on
today,
paying.
Malaj, if I may say this, Malaj, if
You can
your
ask for
lordship-
removal, you can challenge the quantum also before the company.
Malaj, no doubt about that.
Do
Malaj,
that.
and I can do that. But Malaj, today, Malaj, please appreciate that. Why I have approached your lordships now, and Malaj, why perhaps that order, that particular order, Malaj, perhaps have to be stayed. I'll tell you, lordships, why. That if there are no security guards at all, and this is a fictitious sum, this 1,19,000 is a fictitious sum for no work that is being done. And if out of a claim of Malaj, if my admitted claim is 4 crore something, and I've been Malaj asked to, and this, repeatedly now he's writing letter to me, Malaj LIC, that you pay this sum, otherwise you're in contempt of the court's order. You're in contempt of the court order. Now, Malaj, what is today, Malaj? Please appreciate this. On 3rd October, your lordship's court has Malaj put up the genuine apprehension and come before your lordship's court. Now, when we come, because your lordships would see, even
They
in the,
directed the official liquidator to disburse and keep on disbursing the payment. Payment does not mean that they can claim whatever amount they want.
so that's what they're asking for me.
So we'll clarify that this payment does,
Malaj,
this direction does not mean that they can ask for whatever they want.
whom they are actually paying, and because Malaj, bills, Malaj, today, let us understand one thing. Malaj,
I'll
I
give
can,
you liberty to challenge the bills raised by them and the veracity of those bills, the basis of those bills, as well as seeking replacement of the security agency. But the payments, it cannot be that the property is protected because some reasons were given in my order regarding the division bench order being the notional
So,
seal being there.
I am not on that.
Those
Malaj,
premises
notional
cannot be
possession.
recalled in modification.
I bow down, Malaj, but notional possession, that's what exactly I'm saying. When it comes to notional possession does not mean, Malaj, that they will act. So, Malaj, that is why if your
No,
lordship
official seal is there. Once I put my seal, I have some responsibility for that.
I
also.
know.
Because the company code through the liquidator, through the official liquidator,
No
is
doubt about that.
control over that.
No doubt. But Malaj, my greatest of respect, if I may
So
say
if
so,
this is gross security lapse,
not
as
only
appears,
security, this is like we're taking everyone for a ride. If there is no
that does not,
security guards,
we cannot change our order for that. That the
Malaj, in the meantime,
security agency, if it is there, definitely they have to, the official liquidator has to pay it. But if there's a security lapse or some
yes,
there's
because
some
please appreciate one thing.
deficiency in their services or the inflated bills or these things, to challenge me for the company.
Yes, I will do that. Malaj, I'll tell you, Lordship, what has happened now. He is threatening me. Kindly see page 85 once.
Of contempt.
Of contempt.
No, I will clarify that this direction for payment does not mean that whatever amount they want, you'll have to pay. You have a right to challenge the quantum, the basis of the quantum, and also seek a replacement of the security guard. And this order, I'll subject this order to
And
that.
today, merely giving a bill of someone,
Definitely.
it
This
does
does not mean that also.
and it does not prove that there are actually deployment of security guards there.
I'll make it clear that this order does not mean a blanket direction to pay whatever amount they ask for.
Yes,
You have a right to, this order is subject to the rider that
yes.
you are entitled to challenge the quantum, subject to hearing them.
Yes.
Challenge the quantum, the basis of raising the bills, and also ask for a change of the security agency.
Yes. But I am not
This
saying,
order will be subject to that rider.
yes, I am not saying, Malad, for even
That will save you
once.
from contempt.
Yes,
unless you pay
Malad,
over.
I am not even once for saying for a fact that this property need not be protected. Because if the property is not protected, I'll be the loser. Malad, I will
It
be
boils
the
down to a
person
subsequent cause of action actually, because on that date, subsequently you had an inspection and
No,
saw this
which
thing.
is why I have taken out, Malaj, my instructions are that's why I have taken out the application for perjury, because Malad, on the supplementary affidavit, what was stated on supplementary affidavit was a false statement. Because Malad, what was ascertained was there are actually no security guards that were ever deployed.
That we cannot say from these subsequent post facto
Correct, but
inspections.
yes, but Malad, today that's what I bow down. Malad, today
is the
we are
difficulty.
in a company code, we are in a summary proceedings. We understand, Malad, that is the
No, but
problem.
even then we have
Your lordships have the power under Malad.
the
inherent
power
powers
to
under the
do.
Companies
I
Act.
mean, to do what you are asking also.
Yes.
But there's nothing before me to show that previously also this was the state of affairs. That's
Yes,
the
but
difficulty.
in
So
fact,
this does not call for a modification. I'll put in that rider that whatever I said, these three things will be entitled to challenge.
very well, Malad.
And let us hear them what they have to say. Yes, what is this?
Your Lordship,
The photographs are very telltale.
yes, I'm appearing, Your Lordship, on behalf of official liquidator.
Yes,
Your
you are
Lordship,
the
yes,
one.
yes. My learned senior was supposed to appear, Your Lordship.
Whatever. Yes.
Yes, but Your Lordship kindly provide us time to file the affidavit in opposition to this, Your Lordship, so that we can file the appropriate.
So we'll say that none of these are admitted by you, but we'll give them liberty to take out these three things. On these three things, they will be able to challenge. One is the quantum of the bills raised by the security agency, which are being paid by you. Second, the veracity of the bills, the basis of the bills.
Yes.
And also, they will be at liberty to ask for a change of the security agency from the company code. And regarding these allegations, I'll say that since I have not called for affidavits at this stage, at the inception, it will be deemed that none of these are admitted by you. This much.
My lord, I am appearing on behalf of the State Bank of India, my lord. My lord, I am
You are also
appealing
on the same
yes,
footing
my
as
lord, I am
yes,
on the same
obviously.
footing.
There is also, Your Lordship, an appeal pending.
You're the one who is not providing, or
My lord, I'm the successor courier. My lord, kindly consider the order date, last order 10 January, my lord. My lord, LIC
10 January is what they have sought
my
from.
lord, they have, my lord, appeared. None of this allegation was made there, my lord.
No, we have taken it.
My lord, kindly consider the second.
Yes, I've seen the order. Yes.
They have, Your Lordship.
My lord, none of this allegation was made over there.
Absolutely, absolutely.
After third process, my lord, and this allegation, my lord, secret, my lord, in my lord's direction, my lord, we have filed an affidavit disclosing.
Their real cause of action is the bill, inflated bill, they say.
My lord,
The bill they have raised and their subsequent inspection, which shows that there is nobody there.
Let's kindly allow
That
my
their officers are there, photographs
let's
there.
kindly allow my colleague to be there. She was there. I was not there, so I cannot tell what transpired in the court to that day. But she's there. Let her. Please get her.
It is appealing to UTI as well as LIC. UTI has also sent their officials on another occasion, not on the same date. They have separately gone. So it's
See,
the same thing.
permit
They
me
will
to take
also
this
come up with
question.
similar
my
applications.
lord, in that event, my lord can appoint a special officer to inspect, my lord, what is the actual.
Lordship,
Now the-
the special officer will
that-
go, they will deploy
that
somebody.
within the scope of this limited scope of this modification application, I won't go into that fact-finding inquiry. I'll give them liberty. You fight it out before the regular
My lord,
company.
the application made, my
If
lord,
I was the regular company code, I might have directed affidavits and decided this matter.
Yes, that's what.
my lord, kindly record my
But
objection.
your lordships can. This is a matter
There is
which
allegation,
is
my
going
lord,
before
everything
your
is
lordships can do. Well, I
Not the regular determination.
I know that, but all your
That will
lordships,
be a new fact-finding that may have ramifications on the main matter also.
because my main matter, this
Because
is
that I'll be
appealing before your court.
transgressing beyond the scope. This is only modification because it's my order.
Because subject to
My entitlement to this so-called entitlement to this matter is
Always a
my,
privilege.
that it's my that it's my order.
and we are not here to
No, that
you know,
entitlement is actually of
it's-
some other bench.
I never
Entitlement, read entitlement as trouble.
I never have a choosing for that. I have
No,
to
no, no,
go
no,
for a
no question.
particular bench and
Mr.
another.
Banerjee,
Yeah.
none of you
But
choose for.
May I say this, subject to
If
correction
I
by my
thought you chose forums, I'd say that.
but
None of you choose
But
forums.
I'll tell you, Lordships, that my friend who's appearing for the liquidator perhaps will agree, but this is the only matter that is appearing. There is no matter, I don't think, subject to correction.
It is pending, Your Lordship. Not 438.
Code 38 is the company code I'm aware of.
Code 38, yes, code 38.
So you said no.
No, no,
Go with Mr. Banerjee, go with the company.
Lordship,
Code
only-
37, code 37. It is pending before code 37, Your Lordship.
Lordship, only one submission, Lordship, the security agency advocate, he is answerable as to why there were no security guards when there was a visit on.
Definitely answer it.
By two secure
Definitely
creditors.
answer
By two secure
By-
creditors.
By on separate occasions. Lordship, I'm coming up with an application on behalf of UTI
Let a
also.
copy be given upon us, my lord, we will reply to that, my lord.
Come up with that application before the.
But not in the meantime, as your lordship is clarifying this threat of contempt looming large.
No,
on
no,
all
I
of us.
will. As I said, I'll put in those riders. This will
There
be
is no
subject to
threat of
those.
contempt.
My lord, these entire pictures come once the official.
Learned counsel
Absolutely. There is contempt.
appearing for the secured creditor stroke applicant submits that submit that taking undue advantage of the order of this court dated January 10, 2025, directing the official liquidator to disburse and keep on disbursing the payment of the security agency deployed by the official liquidator for the protection of the Mysuru MYSURU. Mysuru ke Mysuru bola? Mysuru property, comma, the purported security agency is demanding huge sums of inflated amounts, comma, allegedly for providing security to the said premises. Full stop. The very basis of such claims are disputed by the applicant. Full stop. It is contended that on an independent inspection held by the officers of the applicant in the modification application, comma, it was revealed that throughout the day, comma, there was no vigil kept by any security personnel at all,
On 4
and it
days.
was open for
For
anybody and everybody to enter into the premises of the company in liquidation in question.
A life insurance company.
I'm for
my advocate
UTI,
on record.
UTI as well as life insurance. company.
Learned counsel, so you are appealing for both.
Because I am appealing for LIC.
Learned counsel for UTI also supports such contention and seeks to file a similar application as the present one on the self-same allegations. First of it is further
But I am also
submitted
supporting.
that the supplementary affidavit, filed by the supplementary affidavit filed by the official liquidator, which was the very premise of the order dated January 10, 2025, did not disclose the correct picture before this court. First up, it is submitted that the applicants are apprehensive that at no point of time was round the clock security provided at the premises in question. First up, next para. Thus, it is argued that the order under modifications sought to be modified and or recalled, thereby absolving the applicants to from making making payment of such inflated sums, for which bills are raised by the security agency through the official liquidator. Who's up next para? Learned counsel appearing for the official liquidator disputes the allegations made. First up, it is submitted that the facts disclosed in the affidavit filed before this court on the earlier occasion depicted the correct picture. First up, next para, it is further submitted that the official liquidator shall use an affidavit to controvert the allegations made in the present application, if necessary. First up, next para, learned counsel appearing for the security agency submits that although the LIC, although the secured creditors were represented on January 10, 2025 before the court, none of these points were raised, and as such, those ought to be treated to be afterthoughts. First up, next para. Learned counsel for the security agency seriously disputes the questions raised by the applicants. First up, next para. Upon a careful consideration of the submissions of parties, I am of the opinion that the allegations now brought have come to light post facto after the passing of the January 10, 2025 order, inasmuch as the photographs annexed to the present application were taken and the inspections, reports of which are filed, were held subsequent to the said order. First of next para, even if it is shown by the present applicant that the premises in question are now unguarded, the same would furnish subsequent cause of action for taking out a challenge to the very basis and quantum of the bills now raised by the security agency through the official liquidator. First up, in fact, in the event the secured creditors are not confident about the legality of the claims made by the security agency, the secured creditors are always at liberty to approach the company court having regular determination to make appropriate application in that regard. First up, in the order dated January 10, 2025, this court had recorded its satisfaction, upon perusing the documents annexed to the supplementary affidavit, that the expenses claimed by the security agency at that juncture had been incurred by them. First up, next para, learned counsel appearing for the Life Insurance Corporation of India as well as UTI, two secured creditors, had contended that the number of security guards may be decreased since the present deployment is incurring huge expenses, upon which leave was given to the official liquidator, leave was given to the secured creditors to take up such issue with the official liquidator, to take up such issue with the official liquidator, upon which the official liquidator was to consider the same. Full stop. It is found from the annexures to the present application that the official liquidator has initiated such an exercise subsequently. Full stop. Next para. Be that as it may, since this court does not find any scope of any ground for modification of the order dated January 10, 2025, comma, the present application bearing such and such is CA number 47 of 22 applications bearing CA numbers 46 and 46 of 2025.
Well, at 46 kindly keeps it before the regular. It's for forgery, so keeps it before the regular bench.
Acha. CA number 47 of 2025 is dismissed, disposed of with the observation that the order dated January 10, 2025 shall be construed to be read along with the rider that the secured creditors of the company in liquidation shall be at liberty to challenge the basis of the claims of expenses made by the security agency as well as the quantum of the bills raised by the said agency. Full stop. It will also be open to the secured creditors to seek a change of the security agency for the purpose of providing security to the premises in question. Full stop. Next para. The order dated January 10, 2025 shall be read with the above riders for all purposes. Full stop. Next para. No address to cost. Insofar as the perjury application bearing CA number 46 of 2025 is concerned, comma, the same is released from my list to be listed before the appropriate bench having determination to take up regular company matters.
My lord, I am also adopting the submission of the LIC. My lord, kindly records that. My
You are for the?
State Bank of India, my lord.
I've said secured creditors in general. You are also secured creditors.
Since I am appearing, my lord, let that be recorded, my lord.
Next.
My lord, one submission, my lord.
Your lordship, they may challenge your lordship, but kindly noted your lordship, they have not made many payments so far.
that's what.
No, this will be read into that.
Yes, correct.
Okay.
I'm so
Much
grateful.
If they challenge, that will be
I'm so
subject to it.
My lord, if my lord pleases kindly, my lord.
Inflated. Folano. Inflated. Ekdom.
My lord pleases kindly, my lord. The record.
Follow.
My lord, one submission, my lord, my lord, is that there is an allegation against my lord, copy the submit.
আচ্ছা হ্যাঁ আরেকটা লাইন অ্যাড করে since one line I am adding,
Yes, your lordship.
since no affidavits have been invited, it is deemed that none of the allegations made in the made in CAN 46 of 2025 CA 46 of 2025 are admitted by any of the respondents to opposite parties.
My lord, let a copy of the application be served upon.
Lordship, if it is disposed of, then what is the need of an appeal?
Copy you should have sent.
Lordship, he never appeared. He's not a
The-
party.
Copies of the application bearing CA 46 of 2025 shall be served within a day on the learned advocate appearing for all the respondents opposite parties. Yes.
My lord, I'm not the opposite party, my lord. My lord, kindly, my lord, I'm not opposite party, my lord, I'm the secret.
So
was
this
never
application,
party.
then
He was
you are not
never
entitled.
party,
If they file an application for this challenging the bills, then ask for that liberty.
Lordship, they may collect it from the OL's office also because they
Give a
are,
copy. What is the difficulty?
No,
Why
Lordship.
why are you so?
I don't even know his address, Lordship. How do I serve upon him?
আচ্ছা তুমি ইয়ে করে দাও তো ওই যেখানটা বললাম যে as well as যেখানটা বললাম যে served on the respondents opposite parties as well as the learned advocate appearing for the security agency. Give your address right now. Yes.
I'm grateful, Lordship.
Pass. Not today. Fourth not today.
Four and
Oh, it is different. Sorry. I thought this is the review application. Yes.
No, my lord, this is
My
the
lord,
application for recalling an
Yes,
ex parte order of appointment of an arbitrator. There was a delay
My
in
lord.
making this application. Directions were given in July, I'm told, for using an affidavit. If they wish to oppose a section 5, no affidavit has been filed till date.
No, this is
Lord,
an
I'm-
application for recall of what?
Recall of an order appointing an arbitrator, ex parte order appointing an arbitrator. And the connected application is the application for condonation of delay in making this application.
What is the delay?
Delays of 255 days.
Explanation?
My lord, the explanation is, my lord, there was no service. A hard copy of the petition was admittedly not served. Hard copy of the 21 notice was not served.
Soft copy was served.
Yes, soft copy was served. There was by service by email. You know, it's a closely held private limited company. I've
Call
seen-
what is this? I mean, why?
I recall because, my lord, recall for two reasons. One, the section 11 was filed before expiry of the 30-day period of the section 21. Admittedly, there can't be any dispute.
Could have pointed that out at that point of time.
Yes, could have been, but the application itself was not maintainable before the 30-day period. It is not like Malad, the 106 notice, it is filed after period of 15 days. Even if it gives a shorter period, it is valid. This is a defect which goes to the
Cannot
root
be
of,
regularized.
this cannot be regularized. Filing before 30 days, and that is evident from the records itself. That will be evident from the records. That it was filed before.
Where is the scope of recall? There may be a regular review application you could have filed. But this is not
Well, it
discovery
was
of
an
prima
ex parte order.
It
That
has to come within the. Oh,
it's an
you
ex
are
parte
not
order.
there.
It is not. I was not there. It's an ex parte order. I could have brought this to your lordship's notice then,
Right.
but I could not because I was not
So
present.
then it's a recall.
A recall.
So what about the section 5?
My lord, I'm being led by my senior Mr. Shataru Banerjee, my lord. Unfortunately, on that ground, I'll pray for a not today.
If the Banerjee is there, then soft copy would suffice. If the Banerjee is there,
Yes.
that soft copy would suffice because he would argue for an hour on this.
Yes, we will. The section 5 will be hotly contested.
It's hotly contested.
Yes, it will be hotly contested.
Yes.
Because there are more than one.
Why
This is
should before he comes,
the section 5 may be allowed.
soft copy was sufficient. I will reject the section 5.
No,
But this is a serious issue. If 30 days had not elapsed,
30 days had not elapsed. That will show from the
and
application.
what is the
itself.
other ground? Just
The
for
other ground is, my lord, a more ground which your lordship had
bigger
expressed.
ground.
According which your lordship said what is the weaker ground, but I think, my lord, the Supreme Court has now said that existence of an arbitration agreement, a physical existence of an arbitration agreement, larger bench has said, must be seen whether there's a valid contract on the arbitration itself, not the overall contract. Fraud at inception and fraud in case of working out. My case, it is fraud at inception because the signatures are forgery. There is no physical existence of arbitration agreement also.
That will be decided by the arbitrator.
That your lordship will, no, my lord, that your lordship will decide whether that is a ground or not. When
30 days, yes.
No, I tell your lordship why. Because I'll show your lordship, my lord, because I was also under the impression that this is a ground which can be urged before the arbitrator. But my learned friend showed me 3 judgments of the Supreme Court. One is Avitel, which has been upheld in Vidya Dolia. Then the interplay judgment and the larger bench on Cox and Kings, where Justice Justice Narsimha's concurring judgment clearly lays down that at the stage of entertaining a section 11, it is correct that you only see the physical existence, but you must determine whether that physical existence is valid or not. If an agreement is signed, my lord, an example there is.
What is a forgery? Forgery has to be gone into on evidence. Absolutely. All palpably on the face of it cannot be. Existence does not mean that existence, then everything pertains to existence. Valid existence.
Valid existence, yes.
Validity, the forgery, that has to be gone into on evidence. That cannot be decided at this. Anyway, we are not prejudging that.
Yes, section 5, my learned he wants time on the section.
Hard copy, soft copy, this is not a good ground at all.
No, my lord, the ground is the soft copy was served, received by email, but the email was overlooked because, my lord, there was a death in the family of the promoter, death in the family of the managing director, because of which, my lord, the email was overlooked, instructions could not be given. That is the only reason which is
not sufficient.
Well, on the
because of your ground, we'll wait for Mr. Banerjee, Mr. Shataru Banerjee.
But on the
because of first ground of recall.
My lord may keep all the grounds open. My senior will.
Yes, my lord is not deciding anything.
No.
We will come his mind against.
Should we direct affidavits in the meantime? Because in any event on the next day, he will be asking for affidavits.
Your lordship may direct without prejudice to the maintainability of the section.
My lord,
the affidavit in the second has not been directed.
No, we will not direct.
My lord, may I
The,
just,
only the section 5.
My lord, may I just indicate this? A direction was made on the last occasion.
Direction
my
from
lord
me.
was, and we
For
have
filing opposition?
Yes,
my lord.
This is the second.
Regarding which? The section 5?
Both the applications, my lord, with the express observation that just because on GA2 there is an AO doesn't mean the GA was
That direction was given.
That
No
was given.
affidavit has been used.
Have you filed?
Our instruction is that affidavits won't be necessary in the sense that client is not comfortable with filing those affidavits. So it will be argued on law on the next date.
If there are no affidavits, these go uncontroverted, then we'll allow it.
My lord, then may just grant me time till next week. I will file the affidavits within the next week.
No, don't file affidavit.
My lord may kindly allow that.
He has said that his client does not want to file an affidavit, may be heard out on the basis of the.
After we express opinion, we'll record your submission that your client does not want.
We were advised to not file it.
You were instructed.
He couldn't.
My lord, we were
They would be advised.
We were
You would be
advised.
instructed. They don't advise you, you don't instruct them. You may instruct them sometimes.
We have the opposition.
An adjournment is sought on behalf of the respondent in the present applications. Full stop next para. Learned counsel for the respondent, comma, upon query of court as to why affidavits have not yet been filed, comma, indicates that the respondent do not want to use affidavits. Full stop, next para. Accordingly, the matters will be heard without affidavits. Full stop. On the prayer of the respondent, let both the applications stand adjourned till
Sure that you don't want
September 12,
client
2025.
বলেছে তো? You're sure?
I তো বলেছে।
Client বলেছে তো?
Yes, yes.
তোমরা নিজে বলোনি
No,
তো?
no, client only.
Client বলেছে?
Yes.
ঠিক আছে। No, I've
Should you record that?
no, your lordship has recorded correctly. Because he's a junior
You
member
were-
of the bar.
Yes, yes, I was also thinking that.
I
was-
so
While
clarified.
dictating,
I clarified. He said yes. Client
My
has
lord,
said that we don't.
I will be candid, my lord. The affidavits are ready, but my senior had advised not to file it, and client
Won't say that.
client has also concurred. So that's
Very
why.
Next Friday.
Grateful, my lord.
Next Friday is other. उसका बाद का Friday. Grateful.
Thank you.
Grateful.
It's the same man. This same order maybe more.
No, no, no.
Oh, six. Oh,
This
six.
is
Oh,
upheld.
Six is-
oh, sorry. It's upheld.
Sixth, usual order is being passed. Yes. Usual order of not today. So, both you were in that? You are in this matter, local? We have been waiting for several days. We'll put, I think, because this matter is going on for some time. Mr. Chaudhary, Mr. Bose,
I have a leader also. So
Whatever,
because he was taking care. I did not come
so
because
the other matters have been kept waiting. I mean, I was seriously thinking whether I should, keep the other matters on some day, but the same fit,
My lord,
this is going on for months
my
together.
lord.
So the other
I'm
matters are
appearing
waiting.
for the petitioner in this matter, my lords.
Please wait for a minute.
Yes, ma'am. Yes.
Just wait for a minute, Mr. Purohit. I will just come back to you. Yes.
My lord, I can of course begin, but your lordship is thinking about Mr. Joyanta Mitra won't be there until 12th. The next Friday is a
Holiday.
huh.
5th is a holiday.
We'll come back on 12th only.
So he will.
That is regarding the next matter.
That is what.
9 to 12.
So
9 to 12.
Then we'll take up this matter.
whatever it is.
Yes. So 7 ডেকেছেন তো?
Yes, my lords.
Yes, Mr. Purohit.
Just wanted to bring to your lordship's attention that the parties have in fact arrived at some sort of understanding in this matter.
Good.
After your lordship hearing it for a long time.
Ah.
But it is to be approved by the bankruptcy court in the United States, my lord.
Right.
And the bankruptcy court is going to take the matter on 10th of September. So if your lordships could give a date post 10th September, we'll come back to your lordships and indicate whatever transpires there and if the settlement indeed.
Very well. So we'll keep it on 19th of September?
Grateful,
Or
my lord.
19th of September.
Grateful.
You are appearing for the
For
which one?
upheld, my lords, the petitioner.
Upheld. Learned Counsel appearing for upheld submits on instruction that the parties are exploring the options of mutual settlement between themselves. Full stop, next para. As such, comma, on the prayer of the parties, comma, let the matter stand adjourned till September 19, 2025.
I'm grateful, my lord.
I'm great.
Thank you. Thank you. Forever. এই আগেরটাও তাহলে না সেপ্টেম্বর 19 করে প্রিভিয়াস ম্যাটার হচ্ছে সেপ্টেম্বর 19 হিসেবে একসঙ্গে আসবে ইয়েস মানে লোকালটা কল
My lord, I'm appearing on behalf of the petitioner, my lord. We are on reply.
Pardon?
We are on reply, my lord.
Yes.
Yes, my lord.
I take the microphone a bit up. Yes.
My lord, so we've gone through the written submissions by the respondent, my lord.
Yes.
It appears that one of the grounds that they've argued on is the fact that the reports of the experts, which have been relied upon by the petitioner, have been considered by the arbitral tribunal, and that the arbitral tribunal has therefore, in fact, not ignored evidence. And that they have submitted that the arbitral tribunal has considered the evidence and has reached a plausible view. And that if a plausible view is reached, then
half a second. This should the actor reply to arguments? Are arguments ne? Notes of arguments? এটা তো আমার নোটস এটা কি ইম্পর্টেন্ট ডেটস জাস্ট পরের আর্গুমেন্ট কাদের কি বলেছে এটা কেটে দিতে বলেছিল না notes of arguments means nothing has been filed because the previous notes I said to file afresh probably.
But I have filed 2 notes, but I have also prepared a
One
third.
I see a cross given the list of dates sort of. that contains something, but you said you will prepare a comprehensive
Yes, yes.
notes. So
Milord,
this I have put a
this has been filed.
this important dates this one.
Yes.
But I put a cross because you said you'll file a comprehensive notes.
This is the
Should I rely on this?
reply.
No, reply is different. Reply to arguments on behalf of respondents that I see, and I only see this important
Yes,
dates.
it's got a cross because your lordship had said that file
I'll
a
ask both of you to
comprehensive.
file comprehensive after going
comprehensive.
through whatever there.
That's why. So, and then I had also filed a reply note on.
This is with me.
Yes, which Milord will be merged in this.
Yes, so I will ignore both and file
Yes.
composite.
Yes. And I wanted to file another note, which is this. I prepared it, but my learned friends, Milord.
You'll file only one note.
Yes.
Comprehensive.
Yes, so they were under the, correctly so, I realized, Milord, that you can't keep filing notes. You finish your hearing.
No,
and
we'll
file a
ignore all the
comprehensive-
previous notes. We'll put a
Yes.
date. This is the and write final notes of argument.
Yes.
Both of you.
Yes.
I mean, both of you. Write final notes of argument. So otherwise, I'll be misled.
Yes.
Yes.
Now, Milord, Milord, now it's undecided note. Really reached, Milord, a short compass.
আচ্ছা আমাকে অর্ডার শিটের একটা কপি দাও সবসময় যে ম্যাটার থাকবে না এটা কারা অ্যাপিয়ার করেছে একটা দিয়ে দেবে ইয়েস সরি মিস্টার
No, no, Milord.
প্লিজ কন্টিনিউ
It's reached a short compass.
ইয়েস
In short, Milord, I had my principal issue was, Lordship knows the background that the tunnel boring machine subsided. Milord, admitted position is that tunnel boring machine, Milord, subsided, as a result of which there was ground settlement. Admitted position is that it was filled with water / muck / grout, which caused it to subside. And the result of the subsidence of the soil was that the collapse of the tunnel, Milord, in parts, and Milord, mayhem on the top, which has resulted in, Milord, financial implications. The arbitration, Milord, proceeds on one single issue really, that who's responsible. Milord, I say, Milord, that they are responsible. They say that I'm not responsible. No one is responsible. It's an unforeseen physical circumstance which has caused this to happen. So therefore, under the contract, this is like a force majeure condition, and liability lies, Milord, where it falls. That's with the owner of the project. This is the whole matter. In the arbitration, Milord, our endeavor was to show that they are not responsible. The contractor is liable in breach of contract, for which, Milord, firstly, we had to show that.
Mr. Shah, since they have already replied, you just address their points.
Yes.
You need not reopen the entire thing. I recollect broadly. So you can just address those, and so that for the purpose of facilitating written notes of argument section.
No, Milord, I just take
You
one
touch
more.
the points so that they cannot say there is something in your written notes which was not argued in court.
No, no, of course not.
So therefore,
Milord, just
give the reply to their whatever they have.
Yes. Milord, in fact, Milord, this was the background, and I am now, Milord, coming to.
There is an issue, as your learned junior rightly pointed out. He started only.
Yes, yes.
That regarding the reports, whether there was a consideration.
Correct.
You say consideration was lip service, basically. I mean, said to be considered, but not considered. They say no, it was considered, and whatever decision.
I have to answer 2 points.
Yes.
That's all. Point one is, Milord, where I left off, I would have gone on to say that my evidence was in the form of, Milord, 3 reports.
Yes.
And their answer to that is twofold. Number one, the reports have been considered in the award. And, Milord, the law is that if there are 2 plausible views, Milord, which are available, and the learned arbitrator takes one plausible view, in that case, Section 34 Code does not interfere. To which, Milord, I have a twofold answer. A, Milord, this is not a plausible view. Milord, 3 or 4 sentences is not enough when there is 3,000 pages of data and material. It's not enough, and I'm going to show the award. and point out those sentences. Second is, the learned arbitral tribunal has also proceeded to, my lord, avoid this, has also proceeded on the basis that the GC, my lord, the engineer under the contract is responsible, which, my lord, I've addressed, my lord, at the beginning in my opening submissions, and I'll also, my lord, show your lordship that it's not correct. And lastly, my lord, I'll just take 2 minutes where claims have been awarded, where, my lord, say, assuming I lose on all counts, even then, my lord, this sort of an award is impossible to sustain, I humbly submit, because where, my lord, I have been held responsible, the learned arbitral tribunal says that I should pay. Where, my lord, the learned arbitral tribunal holds that I shouldn't be burdened, there the learned arbitral tribunal says go and get it from insurance. So the back of the mind, the author of the award seems to, my lord, have proceeded on the basis that the contractor must be exonerated. I have not made out a case of bias, my lord. So
Not made out.
no, bias has, my lord, many forms. Even, my lord, intellectual bias is a form of bias.
Cannot go to that extent.
No, I'm not, my lord, because
Because
all-
the schedules are clear and Arbitration Act 7 schedule,
Yes,
schedule,
yes.
those are clear. We
And
have to
this
be
is
within
with-
some parameters.
no, my lord,
Because
I-
everyone is biased in some sense or the other.
No, no,
Everyone,
no,
every
not
single
that,
soul.
my lord. Not that.
Generally, intellectual bias, every single soul has their own intellectual biases and
No, my lord,
background biases.
I am told, because I haven't ever had the opportunity of, my lord, participating in high-level arbitrations, my lord, outside the country, or, my lord, big arbitrations in the country. We are only doing small matters here. But I am told that the norm is that the nominee of a party is the senior counsel, and the presiding arbitrator is the balancing factor. This is what I am told is the norm. Now, this, my lord, does not, it's an accepted norm, it does not border on dishonesty. But it's an accepted position that if somebody nominates me, I'll bat for him. Which, my lord, at least in our Calcutta arbitration circuit, is frowned upon and not acceptable.
That is the norm in those arbitrations.
That is the norm.
No, no. I completely
Thank God you have
disagree.
not participated.
No, no, no. My lord, that would, my lord, brand, my lord, all of us who've acted as arbitrators, as nominees of parties or otherwise, including retired
Big
judges.
matters. It says big matters. Big
Yes,
matters,
yes.
the definition of big matters as per Mr. Chaudhary's matters where he has not appeared.
No, my lord, here I must stand up to defend the bar.
No, no, no.
It is not, my lord, a normal norm.
It
Cannot
is.
be, eh?
I have spoken to plenty of people who have done a lot of international. I have some friends, my lord, classmates, my lord, who do all this abroad.
Who are equally mischievous as you. So
No,
they
I am
highlight
no-
the wrong things.
My lord, I am known to be, my lord, more mischievous.
So
than
there's
other
a
of them.
tough tussle between three or four of you. It's very difficult to judge by a judge at least. The advocates may
Yes,
say, the
Mr.
counsel.
Chatterjee is, my lord,
Judges, from this end, it's very difficult. I mean,
Mr. Chatterjee is a strong contender for the crown.
three or four of you. Three or four of you are there. That I can gather from this side only. Yes.
Now, my lord, kindly, my lord, lip service or really no service. My lord, please have a look at page. My lordship has the award separately, I
Yes,
believe.
yes, yes.
Page, my lord, 54. My lord, entire evidence is in the form of expert opinion, and the experts have relied upon documents, both sides.
Yes.
Now, please see, my lord, paragraph 97. This is a list of reports. My lord, please come to, my lord, the whole list of reports. I'm not, my lord, going to waste your lordship's time. Now, my lord, see paragraph 98. This is in answer to Mr. Shah's argument that there has been due consideration of reports. My lord, please see paragraph 98.
Yes.
Subparagraph A, B, Now, my lords, please see subparagraph C. Reports are divided to pre-incident reports and post-incident reports, which will be discussed in detail subsequently. There is, my lord, no finding on our argument before the arbitral tribunal that pre-incident reports are of no basis or use. Then, my lord, subparagraph D. Immediately after the incident, claimant had engaged independent agencies, technical experts to ascertain the cause of the incidents. My lord, they're called independent experts. My lord, this is, my lord, a crown which is only given, my lord, to the contractors' experts. My lord, we are not, my lord, treated alike. Then, my lord, these are, my lord, listed. Then, my lord, please turn over the page. It is the claimant's case, what these reports say, unforeseeable physical condition. Now, my lord, please see subparagraph F. These are my reports. F 1, 2, and 3. And G is again their report. My lord, paragraph 99, these are, my lord, the detailed project reports which are not really relevant. But, my lord, project reports and, my lord, the GIR, which is the geo-investigative report, my lord, which is soil condition report. They do borehole logs and take out, my lord, and on that basis, my lord, contract proceeds. That's how they know what is under the soil. Some 10, 20 feet, every 20 feet, they do a borehole log and take out the soil and test it and prepare a GIR. It's, I think, called the geotechnical investigative interpretive report.
It's like a Sunday sort of.
Yes.
You put in the spoon inside and
yes, and they take out the ice
whatever
cream
is
and
there.
test it.
Yes.
Now, my lord, again, so this goes on. So I'm ignoring 9900. It's, my lord, not really relevant. Now, please see, my lord, 101. I'm going to show your lordship the 4 paragraphs in where their reports are considered. 101 starts with the crown.
Yes.
Independent.
That prefix is there in there.
Yes, but that's not given to me.
Right.
Now, to 3 points I want to highlight. Number 1, they have paid for these gentlemen. All technical experts are, my lord, it comes at a cost.
But the experts who authored your reports are not your people.
No.
Shipura IIT and others.
Yes, IIT Madras, who's considered to be, my lord, absolute top level. Then, my lord, Shipur for soil.
So there is no basis for labeling them as independent, their reports as independent,
Absolutely.
and yours not.
And even, my lord, the GC, who's appointed by me, with whom I have a contract,
yes,
my lord, he is giving my evidence. My lord, if I do a suit and a plaintiff goes and gives evidence, you ignore the evidence as biased. That's my evidence. I'm not saying, my lord, that it's independent, GC is independent per se. Yes, GC is my employee, but you have to consider his evidence. You have to deal with his evidence. Now, my lord, 101, I want your lordship to see, my lord, paragraph F 2. Based on newspaper reports as well as reference to historical maps of the area prepared by Colonel Mark Wood in 1784-85 and the map of Kolkata and its environs by such and such in 1792-3. It is this creek that gave Creek Row its name, now Nilratan Sarkar Sharoni, and concluded history of the creek and water bodies assume significance. Old maps show that all the houses are sitting on top of the erstwhile creek. This is, my lord, a newspaper report or an article which is referred to by the expert. And the expert says that from this newspaper article, I come to know that central Kolkata is sitting on a creek. And therefore, the soil must be my lord, full of water, etc.
This accident occurred in Central Avenue in the Chittoranj
Bowbazar.
Bowbazar, right? So it's a bit away from Creek Row.
Yes.
Creek Row was a creek. That's
That's how the
settled.
name. That's how the name
Yes.
comes. But my lord, maybe it's on a creek, but that doesn't mean, my lord, he is to the expert has to show soil condition. You expert, my lord, in one page.
The houses are sitting there for a long time, actually.
Yes, also that reporter dakho.
Maybe.
My lord, I just take
This
your
is,
lord.
yes.
One minute with the
May
report.
not be a very good basis.
This is and my lord, what is important is that this is all probability. My lord, please see the report for 1 second, my lord. This is his report. I want to show it for 1 minute. My lord, I have. This is, my lord, report of.
No, but
Charles.
apparently, if Creek Row is considered to sit on a creek,
Yes.
I mean, then the entire project could not have started. Should have been a non-starter.
কথা বলবে না তুমি আমার রিপোর্টটা দেবে
That's meant for me or
He's very worked up. 426. Volume 3, 426.
Mr. Chaudhary, you argued elaborately. Don't re-argue the entire matter.
No, I'm not re-arguing. Just I want to show one sentence.
You have made your points. Mr. Shah has made his points. Just in rejoinder, just.
Just one sentence, one word.
Yes, yes.
At page 431. One word. Paragraph 2.1.4.
Yes.
Second line. Possibility.
Yes.
Page 433. 2.1.6. During my visit to the site and talking to key people. 2.1.6, page 433.
Yes.
From the information given during my visit to the site and talking to people. Hearsay. What is going on?
Yes.
Then, my lord, page 434. Second.
Mr. Man is an international expert or something, or what is he?
My lord, he is an expert. Of course, he is an expert, my lord. Why would I, my lord, say that he is not
an expert? Otherwise,
yes, yes. But, my lord, my argument before the arbitral tribunal was threefold. Number one is Mr. Mann didn't have the opportunity of assessing, my lord, post-retrieval soil samples. Number two, Mr. Mann's report, pre-retrieval, says there is a possibility. And number three, Mr. Mann comes to this conclusion on the basis of the fact that he looks at certain newspaper articles, etc., to say that this was a creek. So it is possibly correct that this is the soil condition. Now, one thing I have discovered, all the experts, even my number one expert, if I use the expression, Dr. Endicott, because of whom this project was completed, Dr. Endicott also gave a pre-retrieval report where he lists out the different possibilities. And he says that unless there is retrieval and we go down to examine, we cannot say what has happened. And he also says pre-retrieval, this may be a reason. I've disclosed that report. And then post-retrieval, he says that now I say that this is the condition.
So your point is that there was no distinction between their reports and your reports insofar as this independence is concerned, independence of the experts.
No, My lord, there is no
We
distinction.
won't go into another full-fledged hearing on the merits of each of the reports, Mr. Chaudhary. in
No, we
reply.
won't.
We won't.
My lord,
That will
so-
be opening the
so-
entire argument unnecessary wastage of
no,
time.
no, my lord, I won't do it.
We
So-
will put it to whatever you have argued, you'll put in
Yes,
your
yes, yes.
reports.
So now, my lord,
But your answer, because Mr. Shah answered yes, that they had been adverted to your reports.
yes.
That you are denying.
No, I am, my lord, that I am denying. And before that, I am showing that if you see the award, his reports have been considered in a different light.
Bias is not taken as a specific.
No, no, no. So I'm saying,
It's perversity, maybe.
yes,
Maybe
I'm
patent
twisting the
illegality.
logic.
Patent
Then
illegality.
You've paid for your report, you've hired an expert, he's given a report.
Let us see the reasoning. That line of distinction between.
Yes.
Why rejected their reports.
Now, my lord, please come to my report.
You reported the award. Yes.
The award,
Yes.
my lord, award. My lord, yes, my
Because
lord.
Mr. Shah has
Paragraph
placed
108.
71 onwards he has placed. Page
Yes.
71 onwards. Extensively placed that your reports were considered.
Correct, my lord. Page first is, my lord.
71 is probably the
Yes,
first.
paragraph 108. Correctly so, my lord.
Yes, yes, yes.
My lord, this is IIEST Shibpur.
Yes.
My lord, E, my lord, is the conclusion. Then F is also a conclusion. Then G. However, as per the written notes of arguments, the report has made a statement against counterclaim number 4 on page 105 that the respondent, for the purpose of, this is my, my lord, notes of argument,
Yes.
for the purpose of defending the claims made by the claimant and for effective adjudication of the arbitral reference, required assistance from Dr. Endicott, Dr. Pichumani, Guy Bridges. Apart from the independent experts, the respondent have also appointed institutional experts for reports and views in order to defend the claims made by the claimant in the present arbitral reference. This report is one such listed report as per the statement of the respondent. Thus, this is not an independent report and prepared subsequent to the commencement of the case for the sole purpose of defending the case. This raises doubts about the intent and evidentiary value of this report. That's all. So, my lord, whole case is soil dynamics. My report of, my lord, IIEST Shibpur, which is the fulcrum of my case, because that's what is used by IIT Madras also. And this is the only report considering the disturbed soil samples, that is post-incident soil samples.
This considers both pre and post. Para A says.
Yes, yes.
Clause A actually.
Yes. Everything. This is the only consideration of the, my lord, pre is, my lord, in the GIR, post is, my lord, what is taken out and considered.
Yes.
So that goes on the basis of subparagraph G. Gone. So my limbs are, my lord, cut off. Now, my lord, please see the next one. Till now, my lord, there is not one sentence of consideration. Now, my lord, see how IIT Madras goes. The report, my lord, please see paragraph 109. The report was prepared by a team of faculty members from IIT Madras with the help of Dr. Page, stated to be an expert in tunneling and TBM operations, and all photographs from the daily progress report of TBM retrieval. Now, my lord, Dr. Page is consulted by IIT Madras. We give a mandate to IIT Madras. IIT Madras, while giving it, considers an internationally renowned expert, brings him in. Then, my lord, please see B. Statement of claim was submitted by claimant on 3rd November 21, and this report was submitted by IIT Madras on 17th February 22. Naturally, on perusal of introduction, it appears this is not an independent report. Consultants of IIT Madras studied the geological conditions while TBM aspects were examined by Dr. Page. Accordingly, this is a combination of two reports, one by IIT Madras, second by Dr. Page. As per written notes of argument, respondent has made a statement in respect of counterclaim number 4 on page 105, stating that the respondent, for the purpose of defending the claims made by the claimant and for effective adjudication of the arbitral reference, required assistance from Dr. John Endicott, Dr. Pichumani, Guy Bridges. But this is that same quotation. Then, thus, this is not an independent report and prepared subsequent to the commencement of the arbitral case for the sole purpose of defending the case. This raises doubts about intent and evidentiary value of this report. Now, my lord, the next two paragraphs are very important because this is the only consideration on merits my learned friend can refer to. Please, I'm going to read, my lord, paragraph E and F. Moreover, the IIT Madras in the introduction has stated that the report has been prepared based on the data supplied and all photographs from the daily progress report of TBM retrieval. It is important to note that as per the scope of work VDA letter dated 25th February 2021 of KMRCL, the scope included inspection of affected TBM to study contribution of the component of the machine. Importantly, even though IIT has relied on the photographs of the retrieved TBM in para 4.2.9 at page 1014 of SOD, author mentions that quality of photographic evidence cannot guarantee accuracy of the comments made by Dr. Lee Blade's report. Hence, conclusion with respect to TBM brushes is not considered dependable. This is, my lord, one, my lord, comment on the contents of the report. And the second, my lord, is in paragraph F and G. Now, my lord, I request your lordship to once take the IIT Madras report. I'm not going to place it on merits, but please see the significance of this comment. Now, IIT Madras report. This is 7118 second. একটু তাড়াতাড়ি করো। This is volume 43, my lord. No, it starts from page 7086. Lord, I just want your lordship to just, Lord, turn over the pages very quickly without really reading to appreciate the depth of the consideration. And, my lord, ultimately, my lord, it's totally not exhaustive, and it's got diagrams, consideration. Now, my lord, please come to page 7118.
Yes.
Removal of TBM1. The following comments are based on the removal of tail skin brush seal report, revision 6, prepared by Lee Blade on 12 December 21. Please note that the quality of photographic evidence cannot guarantee the accuracy of the following comments made in Lee Blade's report. So, my lord, the copy of Lee Blade's report and the photographs we give, my lord, IIT Madras sees, my lord, the photographs and says that I can't validate Lieblade's report completely on the basis of photographic evidence which you've given me. It doesn't say, my lord, that I can't give the conclusions which I have given. Now, what happens is, IIT Madras, my lord, looks at, my lord, now please see, my lord, from 7118 to 7130. First is removal of tail shield, and then, my lord, some photographs. Then, my lord, page 7121.
No, but it relies on the same photographs.
Yes, it looks at the same photographs.
But they say that Lieblade's report cannot be relied on because of photography.
Yes.
Then
He says that
logic is not understandable. I mean, I say that because of the quality of photographic evidence, which was the basis of your report cannot be relied on. And I rely on the same and give a report.
Yes, also looking at other things. Also, that's what I want your lordship to see. My lord, that's why your lordship may be pleased to, my lord, see.
But every other page there is a photograph. Which are the photographs?
My lord, kindly now come to, my lord, just quickly let me give your lordships the headings so that the consideration will be clear. My lord, please come to page 7089. Paragraph 4, likely reasons. Paragraph 4.1, role of geotechnical and geological condition at the site. Now, my lord, soil analysis is done. This, my lord, soil analysis and borehole logs are considered up to 7092 bottom.
No, that covers the A clause.
Yes.
Known and unknown geological conditions.
Yes.
But the arbitral tribunal's finding, which you placed before me, is on the
B clause.
B
clause.
aspects relating to the TBM operator.
So, my lord, to find out what is the cause of the incident, IIT Madras looks at two things. One is TBM related issues, and the other is geological conditions.
No, two are unrelated.
Unrelated.
Likely reasons for the incident, one could be geological and the other could be the TBM.
Both have to be considered to
Both
come
have
to
to be
the
considered.
conclusion.
But
Yes.
here,
So,
this finding of the arbitrator is on this TBM
correct.
operation.
Look, that's
so for that, photographs are the only evidence.
No, that's what I want your lordship to see.
So show me from
7089 to 7092.
Yes.
7092
yes,
is the first part, geological.
TBM
Now,
starts from 7093.
7093. So, my lord, the background is noted at 7093. Then, my lord, 7094 is the what is the TBM? That's, my lord, considered how it operates.
Yes.
And, my lord, its impact on, my lord, soil conditions, etc. Then 4.2.3 at 7093. This is, my lord, segmental tunnel lining, tapered rings. Your lordship has seen that. 7096, 4.2.3.
Yes.
Now, I'll just take 1 minute here. My lord, what happens is the TBM ejects rings. So, my lord, it's like this goes forward. As it goes forward, it ejects a ring. And then it again ejects another ring. And it's, my lord, curving and going. So, my lord, it's these rings which make up the tunnel. Experts, my lord, see the alignment of the rings.
What does the tail brush do?
Tail brush, my lord, is the safety, my lord, when the TBM is moving forward, it's moving into the realm of unknown with water, grout, etc. Now, the tail brushes, there are 3 rows. Here, here, and here. Now, this tail brush here, my lord, it's a circle around, my lord, the TBM, which not touches the rings. And it's like a toothbrush, my lord, on all sides. And wire brushes, it's this big, it's this big. And in the wire brushes, grease is injected continuously. So it forms a membrane. And as the TBM moves forward, these brushes will not prevent water / grout / mud from coming back into the tunnel or going into, my lord, the TBM. It's a, my lord, if this is, my lord, the circle of the tunnel and this is the TBM, between, my lord, the TBM and the circle are the tail brushes. Now, the second you don't put in enough grease, the friction is so much that the brushes get ripped off.
Yes.
And ironically, my lord, what happens is if you keep pumping in, if you have enormous grease consumption, that means that the brushes are not there. And you're pumping in and losing grease because the brushes are not there to hold the grease. So this is the entire consideration. Based on, my lord, the amount of brushes left, you know whether the maneuvering has been right or wrong. Because if you go too close,
Here the allegation was not sufficiently greased, probably.
yes, so they get ripped off. And with below two allegations: A, not properly greased, it gets ripped off, and therefore, subsequently, the grease consumption is huge because you lose grease. There are not enough brushes to hold them. Second is, if I see the alignment of the rings, not if I see, if the experts see, they find that the placement is not totally correct of the rings. So that shows that the maneuvering was not correct. This is the consideration. The whole, my lord, case is on this basis. Now, my lord, see 7096. Ground support, segmental tunnel lining, tapered rings. So, my lord, with diagrams, IIT Madras shows, my lord, also see 7097. And then, my lord, up to 7097, IIT Madras looks at the way the rings are placed and comes to a conclusion. Then, my lord, 7098 is tail shield. The brushes on the tail shield, these are considered. Then, tail, my lord, 7100, tail seal repairs. And, my lord, please see, my lord, 7100. After all of this consideration, they've also considered examination of photographs during second replacement, and brushes were found to be packed with hardened grout, etc. Then, my lord, some pictures are considered, not photographs, I'm sorry, my lord. Then 7103, tail seal grease requirement is, my lord, considered in detail. Lord, please see 7103. From grease requirement and what, my lord, is the amount of grease spent, you come to a conclusion whether brushes are there or not.
Amount of grease spent is recorded in that machine when it is retrieved.
Yes, that is
Is
clear.
it reflected here somewhere? No.
That is clear, my lord. There, my lord, in the arbitration, when we were arguing this, we do a calculation based on grease put in and number of strokes of, my lord, the engine, which pumps out the grease into the brushes. So number of strokes into, my lord, capacity is equal to usage, which is contradicted by the other side by saying that we dipped in a stick to find out how much of grease was there without any basis. So this is, my lord, the difference in the level of evidence produced. My lord, I'll wait for
Your
your
case
lordship.
is that this was not looked into at all in that sense.
Nothing. You have to look into it.
No basis has been. I'll come back in.
My lord, may I be permitted to mention, my lord? My lord, our former additional Solicitor General, Mr. Y.J. Dostur, died now.
Died now?
My lord.
Where?
At Medica.
Medica Hospital.
At
Medica Hospital. And my lord, our
Actually, he is suffering from
Bolo,
cancer.
सामने से.
Actually, he is suffering from
Cancer.
cancer. That's
Oh. So you're
I have already taken a resolution, already informed the Chief Justice as well as the other senior judge.
And my lord, we are going to Medica.
He's still in Medica?
Yes, yes. Just now, within half an hour.
So tell us what to do, then I'll rise then.
Yes.
Very
Well,
well.
I must, my lord, share a most
Grateful.
interesting, my lord, 30 minutes spent with Mr. Dastur.
Extremely interesting person, and definitely so you people are going there to Medica.
My
I'll see whether I can also. Very well. Yes. Hard in part for further hearing on September 12, 2025. Next. September 12th?
In September.
My lord, 19th, my lord.
19th.